All rise. Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Bruce W. Jacobus, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. Looks like we got 3 civil cases today, so each side will have 20 minutes. On the panel today is, to my right is Judge Cohen. To my left is Associate Judge George Maxwell. Judge Maxwell is a circuit judge in the 18th Circuit, and we're certainly glad to have him here today. If you got cell phones, you got to make sure I don't have mine. Make sure they're on silent so they don't go off. If you need to tell me if you want the appellant reserve time. I got it set for 5 minutes, but I can finally figure out how to work this thing so I can change it if need be. And so our first case would be James Scott Pendergraft versus C.H. as Settler of J.F. Special Needs Trust, I believe. So you may proceed. You want to say 5?
Your Honor, 3 would be fine.
3? Oh boy. Uh-oh. I did it. Okay.
If that messes up your time, I'll go with 5.
It'll turn yellow, that little thing will, but I'll tell you too when you
Okay,
get there.
okay.
All right.
Thank you.
Go ahead.
Good morning, Your Honors. My name's Lucinda Finley, and along with my co-counsel Lane Weinbaum, we're here representing the appellants, Dr. Pendergraft and the Orlando Women's Center. In this case, we have a verdict that's based entirely on a cause of action that simply doesn't exist in Florida law.
Let me ask, when was the request for judicial notice under 390-0111 filed relative to the trial?
It was, as I recall, it was near the commencement of the trial, and the trial judge reserved.
It wasn't a month or so before the trial?
It was slightly.
Because I don't know what you mean by near the commencement of trial. That's somewhat amorphous.
Well, the significant point, Your Honor, is that the trial judge reserved decision on whether 390 could be interpreted as strict liability.
The question to me was, when were you put on notice as to their desire to take judicial notice of the statute?
It was before the commencement of the trial.
Right.
Yes.
And all of the issues that are raised in terms of the constitutionality, did you raise those below?
Those, Your Honor, are details of the argument.
I'm sorry, was that a yes or no?
Those specific authorities, such as the Florida Supreme Court cases of Presidential Women's Center, and were not raised below.
Were there motions filed in terms of attacking use of this statute in terms of its constitutional impact?
That particular detail of the argument about why the canon of statutory construction, that if you have 2 interpretations, one of which supports constitutionality and one of which would render a statute unconstitutional, the argument about that canon of statutory construction was not one of the specific details of the argument that was made by trial counsel.
Right, then why is it preserved for appeal?
Because, Your Honor, it is a detail of an argument. It's a way of fleshing out the points about why 390 should not be interpreted as a strict liability statute.
You're addressing a panel, all 3 of whom, one of whom is a circuit court judge, and 2 of whom have been circuit court judges, and so we're sensitive to the issue of giving the trial court first crack at getting it right. And it doesn't seem that you did that in this case.
Well, certainly, Your Honor, the issue of whether 390 should be interpreted to impose strict liability in medical malpractice was a central issue. Joined.
I understand that,
yes.
But the constitutional aspect of it was not raised below.
No, not that particular aspect. As I
Okay.
said, it's offered here to remind the court of, I said, the basic canon of statutory construction.
Don't remind us of something that wasn't raised below because it's not been preserved.
Your Honor, I would respectfully beg to differ. The preservation rule does not require that every single case and authority that one relies on in the appellate court has to have been mentioned.
You didn't file motions, you know, there was nothing brought to this trial judge in terms of the constitutional impact. Now, you argued that it shouldn't be strict liability, certainly, and you can feel free to argue that. I'm just struggling to understand why it's preserved, and you seem to be arguing some sort of fundamental error, which I view as a very narrow, in civil cases, a very narrow concept.
Well, our position is it's the detail of the argument, but more fundamentally,
A detail of the argument that wasn't raised below.
not every detail of the argument
Well,
needs to be raised.
it's more than a detail. You spend a significant amount of time in your brief arguing constitutional issues that were not argued below. I don't view that as a detail. I view that as a significant argument made on appeal that was not made below.
Well, more fundamentally, Your Honor, turning to the merits of the strict liability issue without regard to the constitutional implications of the strict liability finding, there are reasons that clearly were brought up below as to why strict liability, why 390 should not be interpreted as a strict liability statute.
Right. Now, the appellee argues that if error, harmless error, because there was no evidence of any comparative fault and really no evidence that would dispute proximate cause. Would you address that?
Yes, certainly, Your Honor. Well, first on the causation issue, I think it's quite significant to point out that on their verdict sheet, as pertains to Dr. Pendergraft, the jury actually checked that Dr. Pendergraft did not cause any harm to the plaintiff. So clearly they did not find causation in ruling on the strict liability charge, which further shows how confused they were by the erroneous strict liability charge. And as to the issue of comparative fault, there is indeed evidence from which a reasonable jury...
What is that evidence?
The evidence from which a reasonable jury could find comparative fault on the part of the plaintiff would be that she left the clinic.
She left after they kicked her out. They told her to
Well,
leave.
the evidence, there is evidence...
Told her to leave, don't come back.
There's evidence and dispute on that. That's not exactly what Ms. Howard...
Who testified? The only witness called by the defense was Pendergraft, correct?
Right, but there was put into the record, there was deposition testimony from, I believe it's Ms. Tanya Severance, who was an employee of the clinic, and Ms. Howard, the mother of the plaintiff, testified, and she didn't say she was ordered to leave. She said that there were words that maybe, that with that attitude, perhaps you should leave, or words to that effect. She also acknowledged...
Didn't Severance acknowledge that, she told her, to leave and not come back?
I don't believe that was her direct, precise testimony. And she did acknowledge that nobody escorted her out. She did acknowledge that she went of her own free will to her own room and packed up her belongings and left by a side door.
After being told words to the effect of leave and don't come back.
Yes, but a reasonable jury could interpret that based on Ms. Severance's deposition testimony, where she said that she told her that with that attitude, we won't be able to answer your questions. And
the attitude was that she was in pain and wanted to see a doctor. Neither of those requests under the protocol that was established were going to be honored because apparently they weren't going to wake the doctor up who was in a motel room.
Well, let me remind you, Your Honor, of course, 390 itself, the statute that the court charged the jury as strict liability, that was the sole basis of the compensatory damages finding. Says absolutely nothing about protocols.
What I'm trying to understand is your response to their argument that it's harmless error.
Okay. Well, as I said, even aside from the disputed testimony about what exactly was said.
I'm still not hearing a lot of dispute. The only thing that I'm hearing in dispute is the manner in which she was told to leave and not come back, whether, because it was perceived to be her attitude because she might be in pain and asked to see a doctor. Well, those were apparently unreasonable requests. And so they tell her, to leave because of her attitude. I mean, I don't see how that puts anything in
Well, Ms.
dispute.
Severance's deposition testimony, which was read into the record, wasn't that she told her to leave. It was that with that attitude, you won't be able to get answers, information. It wasn't that she told her to leave. But even once she left, it's undisputed that she drove around for over 45 minutes and went home instead of going to a hospital. I think a reasonable jury could interpret that as irresponsible behavior that contributes to the
Driving around,
likelihood.
it took her 45 minutes to get home because she was in so much pain.
Well, but the point is, she drove home, she didn't drive right to a hospital, and she went home and was at home for a while before anyone bothered to call to get her to a hospital.
Well, but the claim is that the injury that occurred back at the clinic, not while she was driving around.
Well, that raises a really interesting point, Your Honor. What exactly is the injury in this case? The injury seems to be the fact that the child was born alive instead of dead. So the injury, I mean, if that's what it is, which seems to be the only conceivable injury in the complaint, the delivery of the child actually happened at the hospital, not at the clinic. I mean, and that's a fundamental problem with this case. The only plaintiff in the Fourth Amended complaint is the child. The mother was dropped as an individual plaintiff, and that makes this an illegitimate wrongful life claim. And the only injury the child is complaining about is the fact that the abortion that her mother wanted wasn't completed, and she was born alive. And because obviously being premature, that...
And I think you're doing a good job of narrowing, the issues.
Thank you, Your Honor.
The implied consent, was that raised below?
I'm sorry, implied
I'm
consent?
sorry, not the implied consent.
The informed consent.
Yeah, the informed
No,
consent.
we do acknowledge that the issue of the duty of informed consent, or the absence of a duty on the clinic and the owner of the clinic, was not raised below, but it is our position that's a fundamental error. Indeed, as far back as 1933 in Anders versus Nicholson, the Florida Supreme Court...
I think you're going to do better focusing on the issue of the wrongful birth, wrongful life, and the strict liability.
Okay. I just wanted to answer your question that
You did. The answer to the question was that it was not raised below.
Right, but it's, when there's an absence of a duty on a defendant, the Florida Supreme Court has held that creates a fundamental error, which can be reviewed on the first time on appeal. Well, let me talk a bit about the wrongful life, since Your Honor is obviously interested in it. There is a crucial, I know the appellees contend that the issue is already resolved in the prior appeal on this case, but that prior appeal dealt with a second amended complaint, which preceded the fourth amended complaint that governs the trial, and the issue in the prior appeal was solely whether the second amended complaint related back to the initial complaint in the case. We're not here disputing that the fourth amended complaint relates back. What our point is that there's a crucial, legally crucial difference in the fourth amended complaint, which was the one that governed the trial, and the previous second amended complaint. Namely, the mother was dropped individually as a plaintiff. So the plaintiffs are simply representatives of the trusts that are for the child. So in a sense, the only remaining plaintiff that went to trial was the child. And the child is only complaining about the fact that she survived the abortion procedure. She was born alive, but obviously severely prematurely. And all the evidence is it's the prematurity that lead to her problems. So this is a classic textbook example of a wrongful life case, which Florida law and the law of no other state allows. The wrongful birth claim, which was asserted in the second amended complaint, is where the parents complain that there was some lack of information or some misdiagnosis of a genetic condition that led them to not be able to decide whether to conceive or whether to continue a pregnancy. Without the mother herself as a plaintiff, she can't assert that claim anymore. So it's simply dropped out of the case. So this is a case all about, the tragic situation, we're not disputing the tragedy here, of a child whose mother intended to abort her, and she survived the abortion and was born severely prematurely. So what injury can she possibly complain about other than the fact that if the procedure that her mother sought had been successful, she wouldn't even be here to complain. The injury here is, I was born alive instead of born dead. I mean, that claim is emphatically rejected by Florida and every other jurisdiction as a matter of fundamental public policy. So, and this is truly fundamental error. Well, and it's also, that issue was preserved. The trial counsel, as we pointed out, did in fact raise the issue that this was a classic wrongful life case. So the entire case should have been dismissed. It should not even have been tried based on the Fourth Amended complaint. And it said it is simply wrong for appellees to insist that the issue was previously resolved by this court. Now, again, turning back to strict liability, as I said, I remind you, at least for Dr. Pendergraft, you can't have tort liability without causation. And the jury emphatically found in the punitive damages phase that he did not cause, his conduct did not cause any harm to the plaintiff. So that certainly shows there's
They
major
found
harmful
in the
error here.
punitive findings that he was grossly negligent, correct?
The charge was grossly negligent or intentional misconduct, so we don't know which grounds the jury found on, but we do know that they found that he did not cause any harm. You can't have any tort damages, compensatory or punitive, without a causal connection between your conduct and the harm. And the jury here found that that was lacking in this case. So it certainly can't be harmless error for the trial court to have charged them on strict liability and ruled that causation is somehow magically subsumed, and that, you know, you do have to find a causal connection between conduct and harm in a strict liability case. I mean, that's a fundamental principle of tort law. But more fundamentally, I mean, there's nothing in 390 itself which suggests any legislative intent to have it be a strict liability statute. The only place in 390 that ever mentions the professional the standard of care at all is in subsection 4. And that subsection actually posits the traditional professional standard of care.
You didn't challenge the punitive damage verdict based upon a lack of finding of causation, did you?
No, we can see that the trial counsel did not do that. I bring it up to point out that it's not harmless, that the strict liability charge is not harmless error here, because the jury was obviously confused and did not find one of the crucial elements for compensatory liability in the first place. So, I mean, that's the point for which I bring it up as an example, as a very important way of showing it was simply not harmless error. So as I said, 390 itself, the only place it mentions a standard of care, it posits the traditional professional standard of care. And that's particularly significant that it does so in subsection 4, which is the subsection that deals with a situation where the fetus might be viable. And that's where the state's interest in fetal life is at its most compelling point. And if even for that point, the legislature says you only use the professional standard of care, it simply defies common sense to say that in the other parts of the statute, without saying anything, the legislature somehow meant to overturn decades of well-established Florida law embodied in statutes that the professional standard of care prevails in all medical malpractice
Well, the complaint
actions.
didn't allege strict liability, did it?
You're running into your 3 minutes, just want to take a second.
Oh, okay, so would you like me to?
It's up to you.
Yeah. You go ahead and answer.
Obviously, you want me to answer Judge Cohn's question. Thank you, Your Honor. Yes.
Did the complaint allege strict liability?
The complaint,
the Fourth
no, the
Amendment,
complaint
right.
did not. They brought it up, in fact, it came up at the very end of the trial.
Okay,
Yes.
all right, thank you.
Thank you. I'll wait for rebuttal for further points. Thank you, Your Honors.
I'd like you to begin with the discussion of why you think this is a strict liability. And you didn't plead it, and I'm struggling to see that statute as establishing strict liability. You know, this could be a situation where, you know, you talk a judge into something that you later, you know, potentially regret.
We believe it's a strict liability statute, Your Honor, because it's designed to protect a particular class of persons from their inability to protect themselves.
Women?
And that's the
Women?
women who have not been given appropriate information and viable fetuses.
That's not, you know, you're tag teaming then. So the protected class is women who have not been given a certain type of information, you know, for informed consent. I mean, that's not a protected class analysis under any cases that I've seen, or any possible analysis.
Well, the Supreme Court said in Presidential Women's Center that consent obtained without adequate information is no consent at all. But it really doesn't matter, Your Honor, because even assuming it had to be, they're complaining about two things on this strict liability instruction. They're complaining about causation.
They didn't even plead strict liability.
That's correct, Your Honor.
And
But they never objected that it wasn't
tried
pled.
by consent. They were arguing and fighting, you know, strict liability all the way. So how do you end up, you know, on the eve of trial, coming in and trying a case under a strict liability theory when it wasn't pled, and I don't see how this comes under strict liability? I mean,
Well, okay.
The fact that you didn't plead it is real troublesome to me.
Well, yes, but the request for judicial notice was
That's
filed
not
and
a
ruled on
pleading.
well before trial.
That's not a pleading. It might put them on notice.
It did put them on
that, you know,
notice.
that this statute is in play, but that's far different than pleading a cause of action for strict liability. So let's assume, for the sake of discussion, that we reject your argument that this was, A, that it is a strict liability statute, or B, that you properly pled strict liability. You're left with arguing harmless error, so why don't you argue that?
I'm happy to argue that, Your Honor. Number one, they're complaining about two things with respect to strict liability. They're complaining about causation, and they're complaining about comparative negligence. The only testimony about causation came from plaintiffs' experts. And plaintiffs' experts testified. Dr. Gatewood specifically testified that the consents were a sham, they were full of lies. She was told that she would have a doctor. She was told that the fetal heart would be stopped with an injection of digoxin. She was told she would be given RU-486 at the beginning. The purpose, she wasn't told that she'd be given these massive overdoses of Cytotec to induce labor. And the purpose of the RU-486 and the digoxin is so that the fetus will...
Let's talk about the concept of harmless error.
Yes, I'm trying to, because the only testimony on causation came from plaintiff's expert, and plaintiff's expert testified as to causation, that the massive doses of Cytotec that she was not warned about, and the massive, the failure to give the RU-486 at the beginning, and the failure to give the digoxin, all contrary to what she was told in the informed consent forms. That's what caused this child to be born alive prematurely. And the plaintiff that testimony is uncontradicted. And he and another doctor also testified that
Why is that a wrongful life claim?
No, Your Honor, it's not a wrongful life claim. It's a wrongful birth claim. In Cush versus Lloyd, the Supreme Court said that the case is brought by the parents, but the damages for the medical care and the extraordinary expenses are for the benefit of the child. They're trying to convert a Scrivener's error, which they never raised below. They never raised it below. They're trying to convert a Scrivener's error of leaving out individually and in the caption into a different cause of action. The earlier opinion in this case rejected the distinction between wrongful birth, wrongful life that they tried to make in the earlier appeal. They said, no, this isn't
Well,
that,
wasn't the
this is
earlier
medical
appeal,
malpractice.
It's a relation back issue. That's the issue that was decided by the
That was a
court.
relation back issue, yes, Your Honor, but the court, in the course of that, said, the complaint doesn't say wrongful birth, it doesn't say wrongful life. It says medical malpractice resulting in these extraordinary expenses for this child, for which the defendants are responsible. And the complaint still says that. It still says that. And they never raised that below. I looked, I couldn't find where they raised that below after the first appeal. They raised it in the first
So, going
appeal.
back to the harmless error.
Okay.
You think that causation was established by-
Causation was established without contradiction.
Right, and then-
There was no evidence of comparative. Counsel cited to the deposition of Tanya Severance that was read, but there's nothing in the deposition of Tanya Severance that suggests that CH voluntarily left. There's nothing in her deposition that says, oh, she decided to leave. There's nothing in this record that says, oh, she was told, maybe you should leave. No. What happened was, this lady was in terrible pain. This lady asked for a doctor. This lady was told, with that attitude, you can just leave and don't come back. And that's the uncontradicted evidence in this record. Now, there's been some discussion about the verdict forms and our contention that it's harmless error. And so I think there's been a little bit of a distortion or an inaccurate discussion of what happened. It was a bifurcated trial. And in the first half of the trial, the jury was instructed that they had to find at least gross negligence causing the plaintiff's injuries in order to find punitive damages. And so the jury did. The jury was also, by the way, instructed on causation. They were given the standard causation instructions. And they answered the question, do they find by clear and convincing evidence that punitive damages are warranted against Dr. Pendergraft and Orlando Women's Center? And they answered yes to both of those questions. The question that counsel is pointing to as finding that Dr. Pendergraft did not cause the plaintiff's injuries is being misread. Here's what that question says. At the time of the injury to plaintiff, did James Scott Pendergraft and/or the managing agents of the Orlando Women's Center have a specific intent to harm the plaintiff, and did the conduct of James Scott Pendergraft and/or the managing agents of the Orlando Women's Center in fact harm the plaintiff? And so what the purpose of that question is to deal with the statutory cap on punitive damages. If there's no specific intent to harm that causes damage, then the statutory cap can apply, although they've never raised the statutory cap. So all the jury was fine. The jury has to be presumed to be following the court's instruction when they awarded punitive damages in their verdict in the first half of the bifurcated trial.
So your position is that the punitive damage award was based upon gross negligence?
Yes, yes. And I think, he wasn't there. I mean, there were staff there that clearly had some serious animus towards CH. And so that's probably the basis for the finding of yes to that question, specific intent to harm as to Orlando Women's Center. And as to Dr. Pendergraft, well, as he admits, he wasn't there. Didn't have a specific intent to harm. He's just motivated by making money. He wants to, as the jury found, he wants to make as much money off these procedures as he can while he's in jail. So I think that the court really can't construe that question as finding no causation, because the jury clearly found causation in the first verdict of the bifurcated trial, because they were instructed, You can only find punitive damages against Dr. Pendergraft if you find either gross negligence or specific intent to harm that caused the injury. And that's what they found. That's what they found when they checked yes to question number 5 on the first verdict. The question that counsel's talking about is on the second verdict. And on the second verdict, the court must construe it as the jury, following the court's instructions, finding that Dr. Pendergraft did not have a specific intent to harm, and not as a finding that he didn't cause injuries to the plaintiff, because otherwise, the jury would have not been following the court's instructions when they found in favor of punitive damages in the first place. So for that reason, it's harmless. All of these errors they're complaining about are harmless, and all of these errors they're complaining about were not preserved. This court, I filed a notice of supplemental authority, I guess, a week or so ago, the Slayton case that this court recently decided. In order to be preserved for further review by a higher court, an issue must be presented to the lower court, and the specific legal argument or ground to be argued on appeal or review must be part of that presentation if it is to be considered.
I can tell you, it's real troubling to me that you plead a medical malpractice, negligence case, and then come into trial and try a strict liability. I have real problems with that. Why shouldn't we reverse for that alone?
Because it didn't affect the outcome. It did not affect the outcome, Your Honor. Because the jury found that Dr. Pendergraft was at least grossly negligent and caused the plaintiff's damages. And they found that by clear and convincing evidence. And as far as any prejudice, counsel was on notice. One of the very first things at the beginning of the trial, I think it's on like page 22 or 23 of the transcript, is a discussion of whether the court's going to take judicial notice of the statute. So they're on notice that the statute's going to be an issue.
That's a far cry from changing a cause of action to a strict liability.
I agree, Your Honor, and if the jury had not found that that Dr. Pendergraft was at least grossly negligent and caused the plaintiff's injuries, they might have a point, but the jury did find that, so there's no harm. There's no harm at all to Dr. Pendergraft or to Orlando Women's Center. And they blatantly and grossly violated this statute. And the evidence is uncontradicted of it. And the evidence is uncontradicted that that's what caused these horrible, horrible injuries to this child.
You think there was a treating physician? The informed consent, of course, is a requirement or an obligation of the treating physician. Was there a treating physician in this case?
I would have to say it's Dr. Pendergraft, because he's the one who set up and instructed and supervised how these were to be done. There's testimony in the record that there was a meeting with Dr. Pendergraft and with the manager of the clinic and I think Dr. Whitney, of how these were going to be done. The staff the staff continued to use RU 486 without supervision, but he was the only one that ordered that. Dr. Whitney testified he didn't use it, he didn't know how it worked. So Dr. Pendergraft is really operating this clinic and performing these abortions by remote control because they're following his instructions. He has set it up so that these abortions will be performed by non-medical personnel. He knows Dr. Whitney isn't going to be there when the abortions start. He set it up so the abortions are started at 10, 11, noon in the morning, And he knows that Dr. Whitney has to finish treating his patients in Orlando, get some dinner, and then drive over. I'm sorry, but
He's from, on the coast.
I'm sorry, from wherever he was to Orlando, and then drive over, and that he's staying at the motel down the street. He's not examining any patients. He comes in, he signs the forms in blank. If you look in the record at the exhibits, you'll see that there's a recovery room form signed for Ms. H. She was never in the recovery room. And Dr. Pendergrapht knew that Dr. Whitney was not going to be available when these abortions started. He knew that Dr. Whitney wasn't going to get there at night. So what he was trying to do was he was trying to be the treating physician from the prison. And that's, I believe, is what the jury found. And the statute specifically requires, and I think the Supreme Court and Presidential Women's Center emphasized, that each informed consent and each decision has to be based on the individualized considerations of the particular patient. And the system that Dr. Pendergrapht
What if
set
there was
up-
no treating physician?
It's got to be him. It's got to be Dr. Pendergrapht. He's the one that's telling them how to do it. They're giving RU 486 because that's how he told them to do it. He's the one. And if there isn't a treating physician, then he's the one that's making the violations of the statute happen. He's the one that's making the abortions happen. The staff is following his protocols, his procedures that he set up. They're giving the RU4, he hired the staff, he gave them what little training they had. And he's the one that is responsible for whatever care.
You make a case for him being a responsible physician, a managing physician, but the mythical treating physician, because there's none of what you have said indicates that he's treating anybody for anything at all. He's non-existent. I appreciate your remote control. He has set it up, he's put it in movement, he orchestrated it. But to say that transmutes into a treating physician, he is a non-treating physician. He's not there for anything.
He's not there for anything, that's right, but he set it up to run that way. He's the one that set it up to run that way.
So the best you could say, he's the nominal treating physician.
Yeah,
I'll buy that.
he is. But he's the moving force behind all of this. He's the one who selected these employees, who trained these employees, who set up these procedures, who told them which medications to use. He designed the consent forms. He arranged for them to obtain the signatures on the consent forms. I won't say he arranged for the informed consent, because there clearly was no informed consent here. This lady never saw or spoke with a doctor. She was never examined. She was never counseled. She was never told how her abortion would be carried out. She was never told of the huge health risks to her from the way this abortion was being carried out. And she testified that she would not have had the abortion had she been told that, because her whole reason for having it was the prior health problems that she had had. So everything that Dr. Pendergrapht did, including violating the requirements of the statute that the abortion be performed by a physician, violating the requirement that the physician personally explain to the patient the risks and the benefits, everything that he did was a deliberate violation of that statute. And I see that my time is about up. None of these issues were preserved, Your Honors, and it's set out in the brief.
The strict liability issue was preserved.
Well, the strict liability issue was preserved, but not the way they've argued it. Not because they've argued it as a constitutional issue, and they did not argue that below. And we would respectfully ask that the court affirm.
Thank you. You got about 2 minutes, a little over.
Okay, thank you, Your Honor. Several important points. On the harmless error, I think it needs to be stressed that fundamental error is, according to the Florida Supreme Court, never harmless. And fundamental error includes when a cause of action that does not legally exist, such as strict liability for medical malpractice, is the basis for the compensatory damages judgment. And that's exactly what we have here. We have a compensatory verdict based entirely on a legally non-existent cause of action. That is a classic textbook case of fundamental error, which can never be harmless. Furthermore, on Appley's harmless error argument, I think they're asking you to interpret every single general jury instruction their way. They say for punitives, the jury was instructed on gross negligence or intentional misconduct. Well, please assume they found gross negligence. On the causation one, they say the jury was intended...
At the PENDERGRAFT, they found, why didn't they find gross negligence on PENDERGRAFT? How do you interpret this any other way?
Well, because this just came out.
Did they find that he intentionally was trying to harm the woman?
They found that he did not.
Okay, so what other basis would they have had to find punitive damages?
Well, as the intentional misconduct, as
Which they found
Appley
he
just
didn't.
argued, that she's contending that he deliberately set up a protocol that violated a statute. That's intentional misconduct.
Well, but it's not intentional harm to a particular person.
Absolutely not, and no particular cause of harm to an individual either, which again is the problem with their whole harmless error analysis. You cannot assume that based on the jury being told strict liability, and if you find strict liability, don't consider any other issues, skip right to damages, that the jury actually considered any of the required elements of a compensatory damages.
If there's no evidence to support any disputed issue in terms of causation or in terms of comparative fault, why isn't this harmless error?
Well, on causation, as Appley said, it's undisputed that what caused the child's injuries is premature birth. And in her argument, Appley's counsel kept emphasizing, well, the mother wasn't told that Dr. Whitney does things differently than Dr. Pendergraft, that Dr. Whitney wasn't going to use digoxin to stop the fetal heartbeat. Well, that's a classic illustration of why this is a wrongful life claim, because what would have happened if Dr. Whitney had, in fact, followed Dr. Pendergraft's protocol and used digoxin? The fetus would have been dead before the drugs were even administered. She would have been born dead, which is really what this whole case is about. They're complaining that she wasn't born dead. That's a wrongful life claim. It shouldn't have even been tried. It should be reversed.
Right.
Thank you.
All right, thank you very much.
Thank you.
I meant to tell you all too, we're going to take a break after this next case for coffee if you'd like to join us in the lawyer's lounge. So between 2 and 3, we'll take a break for about 15 minutes.